Okay, so I'm gonna start talking now about the exam, which is scheduled for next week. I've already completed it. I'm gonna have to go over it again, obviously. What I did was I have it multiple choice and true and false. And I think I have it at 33 questions, multiple choice, A, B, C, or D. Each one is worth 3 points each. One of the questions, I think it will note it, I think it's the last question on there, it's going to be worth 4 points, which gives you a total of 100. And then I'm going to have either 2 or 3 true and false questions, and those will be extra points. So you have a potential of getting maybe 110 on the exam. So even if you screw up 1 or 2 multiple choice, if you do well on the true and false, then it'll still bring up your grade. So those are like extra points so you can do well on the exam. The exam, just so you know, the way I test, this is obviously, I'm going to have to assume it's an open book exam. So you're going to be going back to the notes I give you. Again, the best way to study for this exam is to have been reading all along and really just listening to the lectures. And during the lectures, when I tell you to write something down, it's because it's a topic that I test on. So it's important for you to just kind of write it down and look at that. Is it straight word for word from lectures? Some of the questions are. When I ask you what the burden of proof is in a criminal case, you should know what that is. That's a clear-cut standard. If I ask you what the burden of proof in a civil case, you should know what that is. If I ask, what is the case of Paul's graph versus Long Island Railroad? What is the main topic here? What are you learning out of that case? What is the one thing you're learning from that one legal concept? You should know what that is. There's going to be questions, though, where you need to apply the knowledge and kind of figure things out. So it is open book. The exam will go live at 6:30 next week, and you're going to have the full class lecture to do it. And when I say full class lecture, you're going to have from 6:30 to 9:15 p.m. If you have a documented disability that I've already been notified of, you can get time and a half for that. So just send me a quick email reminder. That's fine. But the exam, I'm going to have it go past the time in case you are under a disability, but as I get notified of the time, that's when I'm going to kind of like cut things off. So just make sure that you follow that. If you have any questions on material from now until the point of the exam, which is next week, not the day of the exam, okay? Because Wednesdays are actually my busiest day at work. It's my calendar day. So if you have any questions about topics, please try to read the material and watch the videos and look at your notes before contacting me. But if there's a topic that you need a little bit of extra help on, just email me and we'll set up a time to talk. So that's that. Do we have any questions on the exam before I go over material now? Going once?
Indirectly related to the exam, were you able to post a video from week 1 or no?
No, because week 1 we didn't record.
Yeah, gotcha.
So week 1 we didn't record, that was on Skype, but week 2, which was last week, I put up, hopefully you're all able to access it. It is on Blackboard. It's a YouTube video. It's about 2 hours and 15 minutes or so. Okay, any other questions? Oh, I see a little pop-up here. Is there a list of topics which will be on the test? The topics will be everything on the syllabus from lecture 1 until the end of today. So everything that's covered in that first third that we're covering, so criminal law, torts, negligence, accountant liability, intellectual property, everything that we're covering until the end of today is fair game on your exam. So again, the best way to review is to make sure that you look at your notes, the stuff that I told you to write down, that's what you focus on. And again, it's going to be open book exam. So, and I think it's pretty much in the order of the syllabus is how I did it. So like the first few questions are probably like criminal law related. And then the last few questions are about the topics we're going to cover today. Okay. Anything else before I get into it? Because I want to make sure that I cover everything, especially I've been working on the exam the past few days, so things are fresh in my mind. Yes.
Sorry, I have a quick question.
Sure.
So basically, that video, if we study that video and we go over the topics you mentioned in the syllabus, we're good, right?
Yeah, make sure, and it's also stuff from the first, like the first lecture. So the first lecture I talked about, you know, criminal law, and I
Mhm.
talked about the difference between, you know, morality and, but not, there's not too much stuff on really morality. It's like
Mhm.
criminal stuff and civil stuff.
Yeah.
So if you study that stuff, you'll be fine.
So
And
is it?
again, yes, go
Yeah.
ahead.
Sorry. Do I concentrate more on like definitions and stuff, or do I look more at like the cases you gave us?
It's gonna be a little bit of,
Mixture.
yeah,
Both. Okay.
yeah.
All right. Sorry. I just wanted to
It's
know
okay. No, no,
exactly.
no,
I
no
never took
problem.
this class before. Yeah. Thank you.
That, no, I don't think anybody else has.
Okay.
So you're all
Yeah.
in the same boat.
Appreciate it. Thank you.
No problem. Okay. Also, what I want to do is for the student enrollment verification, okay? For student enrollment verification, there were some students that so far I have not heard anything from, but maybe you're watching and I just don't know. So I'm going to say your name now. If you are on the video, either say yes or just put a note in the chat. That way I can review the chat later. First person is Tamik Ebony Bailey. Tamik Ebony Bailey. Second student, Daniel Michael Brown. Daniel Michael Brown. Let me see who else. Next is Abdulrahim Husseini. Abdulrahim Husseini. Next is Anlin Liu. Anlin Liu. Alexandra Marone. Timothy Miller. Did I have that one? Timothy Miller, you're on here, so let me just mark you out. I see that already. Renique Scott. You're here, Renique? Okay, good. So you've meaningfully participated just now. Terrific. And that's it. So I got, oh, let me see here. Here, okay. There's somebody with a phone number, and I don't know who that is. So Daniela Santarpia, yes. I don't know what that is here. Who's 875? 8003 8913. Anlin Lu, that's you. Hold on. Just want to make sure I don't forget anyone. Okay. That way it does not change your status. I don't know what that means. Okay, NVM. Okay, so that's it for these things. I'm going to start now with the lecture so we can kind of get right into it. So the things that we left off with was chapter 48, and chapter 48 kind of it carries through from chapter 47, in which we're talking about, again, property, but now we're concentrating on real property. And when we talk about real property, it's how it's owned. And the best way to own a property, this is listening stuff, okay? So this is listening, not writing down, but like for educational purposes if you want to write down. So fee simple is, that's the best way to own something in fee simple. The words fee simple, it means that you own something absolutely. And it can be sold, it can be passed on by a will. It gives you the greatest concept of ownership interest. And so when you own things in fee simple, you can give it to somebody else. So a lot of times in law school, they say to be in fee simple, meaning I'm giving whatever I own to be forever, to hold and to do whatever. Sometimes when you own things, there's a qualification. And the qualification is I own this particular piece of item, and but it's not absolutely mine, meaning you can own something as a life estate. And a life estate is most common, and again, this is listening stuff, not so much writing down, but let's say you own something and a life estate. The most common way for me to describe it to you is, let's say husband and wife are married, they get a divorce. Now wife marries husband number 2. Wife owns a house. Wife loves her second husband. However, she wants to make sure that when she passes on, her kids ultimately get the house. But she doesn't want to kick husband number 2 out to the street. What she would do is, in her will, she would say, I give my house as a life estate to husband number 2, meaning he can live there for his duration of life. And then after that, the ownership of the house reverts to whoever else she deems. So the language be most typical, like, I leave my house to my husband so long as he shall live. Upon his death, it shall pass to my children. So the children actually have an ownership interest in this house. It's not theirs yet. It's eventually going to be theirs. But the husband number 2, can live there as long as he's alive. Can he decide to move out at any time? He can, but he has an interest to actually continue living there. Now, more specifically, when this stuff is actually used, what you'll see that the specifics are usually added in that like provision by saying that as long as he lives there and pays for the upkeep, as long as he's able to keep up with the utilities, as long as he's maintaining the property. Because what you don't want is, you don't want somebody to be living there knowing that it's only a life estate, and then what happens is that they're not paying the bills. Let's say they're not paying the water bill, they're not paying the electric bill, they're not paying the taxes, they're letting the property deteriorate. What can somebody do? What are the kids? What are their options? What can the kids do, if anything?
Can sell it if they want it, like if they get some kind of arrangement.
They can't sell it yet because he's still alive.
Kick him out.
They can try to move him out, but based on what? Their interest is, they have a remainder interest. They are contingent owners. That house actually belongs to them. So they're going to come in and say, we are the actual eventual owners, so we need to make sure that this house is in the best condition it could be. And if he's not paying the rent and he's not abiding by the terms of the will, then they can commence an action to have him removed. They can commence an action to have him pay. They can commence an action to have him possibly have pay penalties for the waste that he created. Okay, so that's basically a life estate and remainder. So when I talk about a remainder is the interest owned in a piece of property after somebody dies. I'm looking at my notes again. I just want to get into the stuff that I know I'm going to test you on, so this might not be as extensive of a lesson. Okay. I didn't test on that, don't worry. Okay. I'm going to just tell you briefly about this stuff because for knowledge. Waste is exactly what we spoke about just a few minutes ago. It's when somebody owns or lives in that piece of property, but they're not actually doing what they're supposed to be doing. They're letting the real property deteriorate in value. And so by deteriorating in value, it's actually now becoming less valuable for the eminent owners. So you can have life estates to people, but they can't destroy the place while just living there. A future interest is an interest where you're giving it to somebody and their heirs, in the future. So I leave my house to my children and my children's children. So my kids can have this piece of property for life, and then upon their death, it can go on to their heirs. This is something to write down. Ready? Write this down. A reversion. Reversion is when you give something an ownership, but it can revert, meaning go back to the grantor. The grantor is the person that originally gave it. So a reversion is when you give something away, but that it has the potential to revert back to the grantor. So I give my house to the Staten Island Museum for them to use so long as it's being used for charitable purposes. So the example is, I give my house to the Staten Island Children's Museum to be used as a museum, whatever I said the first time. Once they stop using it for that specific purpose that I intended, my house will revert back to me. Now, I'm dead, so I'm not actually getting the house, but then it can go back to my heirs at law or the remainder people I originally listed in my will. Does that make sense? It's like you're giving something away, but you're attaching strings to it. So it can, so you can get kind of like what you ultimately want. Like there's actually a lot of houses. If you're from Staten Island, if you're familiar with Howard Avenue, Casa Belvedere. Does that sound familiar to anyone? Casa Belvedere?
Yeah, absolutely.
Okay, so Casa Belvedere was actually a house that was owned by a family. And in the will, it was given to a museum to be used for Italian purposes. So it was supposed to be only used for Italian purposes only, the enhancement and the education of Italian culture. Whether or not that's really what's happening now, I don't know. I'm not going to comment one way or the other, but that was a piece of property that was owned by, you know, a very wealthy family.
They turned it into a catering hall, basically.
Yeah, I know. I just didn't want to, you know, kind of go out there and do it. So I don't know whether or not there's family that's fighting for it. Like, I don't know. I know that the case was actually in my court at some point for something, but I don't, you know, I'm not following that particular case. So, so that's reversion. That's now there's other like types of interest like vested remainder, contingent remainder. Those are kind of fun to know, but I'm not going to test you on it. So a contingent one is where you say, okay, I'm going to give my piece of property to A for life, then to her children. But what happens if A doesn't have any kids? If A doesn't have any kids, then I give my piece of property to B. So B is a contingent remainder, meaning maybe they're going to get the money and the house, or maybe they're not. So a contingent remainder is somebody that potentially has an interest in the real property, but not necessarily. So again, the example I'll give is in a contingent remainder is I'm giving A to A for life and then to her children. But if A does not have any kids, then I'm going to give my property to B. So B, they really don't want A to have any kids because then B can get the property. Otherwise, they're going to be screwed. They're not going to get anything.
This
So,
is similar in financial terms to like a revocable trust.
Not really, because a revocable trust, it doesn't necessarily, like a revocable trust is a document that will lay out a whole contingency plan. It may have contingent remainderment or not. It could very well have like the life estates and all that stuff. The only thing about a revocable trust is the grantor can revoke the entire document. So I guess it's maybe like a reversionary aspect, but usually a reversionary aspect in a will takes place after somebody's dead. In a revocable trust, they have the authority and the ability to revoke it during their lifetime.
Gotcha.
And also, don't forget, I drafted. I used to draft in private practice, revocable and irrevocable. And for a fun fact, in case anybody wants to know, I don't think anybody does, but I'm going to tell you anyway. The difference between a revocable trust and an irrevocable trust, and the reason they're typically done is so you can safeguard assets from creditors like nursing homes and Medicaid. So when you put assets in an irrevocable trust, and let's say for Medicaid purposes, it's assets are in there for like 5 years, and then you have to go into a nursing home, the nursing home can no longer touch any assets held by the irrevocable trust because you don't have control. You cannot revoke that trust anymore. You cannot revoke any assets you put in there. You can only have access and revocation power in a revocable trust. Just a fun fact in life, okay? So I'm going to move on to something that I want you to pay attention to. This is now, we're not talking about ownership so much, but we're talking about landlords and tenants and leases. So if you are renting a piece of property right now, or if you are the landlord, this is stuff that you want to pay attention to. And I'm going to let you know when I'm testing on exam stuff. So typically, what is a lease? So a lease allows you to have access or possess land for a temporary period of time, but you don't actually own it. So if you're renting a piece of property, you're renting the apartment, you're renting the house, you can live there, you can possess it, but you don't have the right to own it. You don't own it, it's not yours. So if you don't, you can get kicked out, it's not yours. And a contract typically exists between two people, a landlord and a tenant, and there's certain implied warranties and constructive conditions. So when we talk about the obligations of landlords versus the obligations of tenants, what do you think, if you are the tenant, what is your obligation to the landlord?
To pay rent.
Okay, perfect. That's it. You got to pay rent. That's all you got to do. As a tenant, all you have to do is pay rent. And now you as the tenant are paying rent. You have the ability to enjoy the piece of property. You have a right to habitability. Okay, now I'm going to start talking to you about certain examples that you need to know, okay, for the exam and for life. If I was to tell you that I'm the landlord, and let's say you came and you viewed an apartment because I was showing it, and you came to the apartment, you saw it was a 2-bedroom apartment. The color of the walls were a nice, beige color. Everything was clean, dandy, great. You said you're interested in it, and you're going to move in, October 1st. Now you come in, it's October 1st, and you get the keys to the apartment and you go in, and it is painted black, like black. The walls are all black. You go into the kitchen, the faucets are not working, the toilet is not flushing. Now, is that an apartment that you can withhold rent from, let's say, or is that considered habitable? Can you habitate that apartment?
No, you can't.
Well, you can argue one way or the other, but generally speaking, no, you cannot. This is not, number one, what the contract between the two people were, right? It's not the apartment that you saw. You are not able to habitate and enjoy it. Why? Toilet's not working, the water's not working, the walls are a completely different color. And we're not talking about a color where it was, between cream and eggshell or off-white or white. I mean, it is a stark difference between it. So it's not something that you can kind of perhaps live with. So you may have the ability to withhold rent, but you cannot withhold rent, let's say, if you go into the apartment and instead of it being cream, it's now eggshell, okay? You can't decide to hold rent if the temperature of the apartment, because you're not able to control the temperature, if the temperature is, let's say, 70 degrees instead of 72 degrees, right? If you have no heat in the apartment, then you can withhold rent. If there's a rat infestation, then you can withhold rent. But you can't withhold rent willy-nilly because you feel like it, okay? So I'm not going to get into rental implications now during the time of COVID. We're just talking about the law generally also, okay? I see notes here. Hold on. Keep house clean and clean. Yes, you can write in the chat, please. What would you like me to write? Okay, so that is that. Typically speaking, if you're going to be renting for more than a year, it has to be in writing. There has to be a lease. If it's a month to month, you don't actually have to do it in writing. I'm a big proponent of having everything in writing because it covers both parties, but it's not a required, within the confines of the law. This is now listening stuff. A tenancy at will. So if you have if you're leasing an apartment and you have this thing called tenancy at will as part of the contractual agreement, meaning either side can terminate the contract and the lease as long as they want to, as long as proper notice is given. So if I want to, if I'm renting it from somebody and I give them a 30 days notice, I'll be able to do that. The landlord, if they want to evict me, as long as they give me a 30-day notice, then I should be able to go out as well. That's a tenancy in common. This is something that I want you to know the difference of. So this is a write it down moment, and that's the difference between an assignment and a sublease. So an assign, and here because somebody requested, I'll put this in the chat for you guys. Copy, chat. Okay. To everyone. Okay, so an assignment. You might have heard this before, like you've heard the term sublease probably more so than an assignment, but the difference between them is this. Let's say I'm a tenant and I need to, I'm going to California. I signed a lease for 1 year and I'm going to California because I just got this great job offer, but I can't leave my my lease is for an entire year. So if I have to get this done with permission from the landlord, but if I assign my lease to somebody else, they are actually stepping into my shoes, meaning they are taking over my lease. So if I am, my lease is from January 2020 until December 2020. In February, I get this opportunity to go to California. I still have from, March 2020 until December of 2020. I need the landlord, it's not their fault that I'm moving. So if they allow me to do an assignment, I can rent it out to person C, and now C takes over my lease. Their name now is part of the lease. Their relationship is with the landlord, and I am completely out. However, with a sublease, somebody will come in still, live in my apartment, but I am still the middleman. I am still responsible to my landlord. I am still responsible for anything that happens. It's creating an extra relationship between me now. I'm the landlord to this other person within the same piece of property. So when is that going to happen? Well, let's say the person that's going to be renting, they have awful credit. And so the landlord, they're going to let you sublease it, but they want to still hold you responsible. And if you're in a bind and you don't want to break the lease because there's going to be penalties and you're going to have to pay anyway, you'll say, all right, I'll be responsible for my little brother or sister. I know they have sucky credit, but I'll still be the person responsible to pay in case they don't. So the sublease, again, there's a reversionary aspect to it. Me, as the original tenant, I am still responsible. Whereas with an assignment, I'm completely walking away from this lease. Somebody else is taking it over. The relationship now in this contractual entity is between the original landlord and the new tenant. Whereas with a sublease, it's still original landlord, me, and then the tenant. So it's an ABC rather than an AB. Make sense? I don't see any faces at all. So I'm going to just say mess. Okay, great. Somebody's
Yeah,
agreeing.
makes sense.
Perfect.
Good.
Okay, great.
Yeah, it does.
Perfect.
All good.
Thank you. You're all alive.
Thanks,
Excellent.
Marissa.
Okay. Again, this is now back to listening, practically speaking. Most leases are not going to allow you to assign or sublease without consent because they want to know who's going to actually be living in their apartment. So that's that. What happens if a tenant does not pay? You guessed it. You've heard this before. The landlord's going to move to evict. They're going to try to, work something out, but there's essentially a breach in a contract. And so then you're going to move to evict. Depending on the state that you live in and depending on the sign of the times, the eviction process could take a few months and could take up years. That's just the way the world works. The landlord's obligation is to allow you to enjoy the premises without any problems, right? To make sure that the common areas are safe, to make sure that, let's say, snow and ice are removed from the outside, that there's proper lighting, right? So those are the landlord's obligations. Who wants to tell me about this case, home rentals versus Curtis?
I can talk about it.
Okay, great. Go ahead.
So there was a group of 4 students back in the 90s that needed an apartment for the new school year, and they met that person of that agency or whatever. So they saw the property. Property was great, everything was up to date, renovated, clean, whatever. So they signed the lease in February, and so the lease, the signing date was September 17th on the next year. So once they went back for the beginning of the school year, they got to the apartment, and the apartment was completely different. So there were some leaks, there were cockroaches all over the kitchen, the carpet smelled, there was a hole in the wall, the bathroom didn't work. So basically it was inhabitable.
Right.
They pay, I think, around $2,000 for the whole, for 2 rents and $500 deposit. That happened in February, so I'm going back and forth. Sorry
Okay.
about it.
That's okay.
And so they contacted real estate corporation or whatever was that, the management, and they said that it's inhabitable and they need to fix the place. They told them just to clean the place and keep living there. So they refused and they stepped out. And what happened? The property management, they started suing them, and they wanted the around $7,000 for the whole year in rents to cover the contract basically that they signed. And in the end, that the four students, they got their money back, the $2,000. They won the case. And that's what I remember though from the whole story.
No, you did great. You did great. This was a case about constructive eviction. So I'm going to just recap really quickly, but you did a great job with that. Some students wanted to rent an apartment. They see the apartment, everything looks great, wonderful. They put down a deposit. They come back sometime later, and now the apartment's got cockroaches all over the place. It smells, there's holes in the walls, it's not habitable. And so they let the management company know, and the management company says, all right, you guys clean it up and we'll reimburse you. They're like, no, we're not gonna do that. So they decided to break the lease. Now they had a lease. They broke the lease and they left. And the management company sued them for the rest of the money that was owed to them for the entire duration of the lease. But the court found in favor of the students, because basically the court said that they were evicted. It was constructive eviction, which means this was not a place that was habitable. They could not live there. It was not conditioned for them to live there. So it's as if they were basically evicted by the landlord. So that was a good outcome. I agree with the results in that. Sometimes there's cases where I'm like, I wouldn't have done it that way, but great job, very good. There's another case also. I'm gonna just talk to you, unless somebody wants to volunteer. Tucker versus Hayford. It's about the bad water. Anyone? Okay, I don't really usually test on this one, but
I didn't get that one at all. I'm sorry.
That's okay.
Yeah.
So it's just a case about people moving into a piece of real property, and they drank the water and they got sick, and it was well water, I believe. And so there are some things like water where they need to be there has to be a representation that's made, an accuracy made when you're giving that, because water is something that you need to sustain life, essentially. And so you're not expecting to drink water and then get sick. Now let's go apply that to what's happening in Michigan, I believe it is, right? With the water. Water is something that you expect to drink and maintain health. Okay, the fact that it's not being supplied to you or cleaned to you by whether it's your landlord or whatnot is something that you would typically sue on. How this state of Michigan is not, or that there's no better outcome for that, I don't know. That kind of boggles my mind in the year 2020. But we have so many other things going on, earthquakes and killer bees and things like that. So I guess bad water just kind of fits in with everything else. So don't worry about Tucker versus Hayford. I don't recall testing. In my original tests, I would test on home rentals versus Curtis as a short answer, but since I'm not doing short answers, I don't think I tested on that. As far as this is listening, again, repairs. The landlord does not have a specific duty to repair things in your apartment unless they were part of the apartment. So if the refrigerator breaks in your apartment and you're leasing, yeah, you're going to notify the landlord and they have an obligation to fix it because the refrigerator came with the apartment. But if your microwave breaks, and it's a microwave that you had brought from Walmart, and then you want to have the landlord fix that or replace it for you, chances are that's not going to happen. Now, how do you maintain, or how do you know what's going to be fixed and what's not going to be fixed? Easy. It would be in a lease. And whatever you put in a lease and both parties agree to before the actual tenancy, that's what would happen. So that's why I'm a big fan of contracts and leases and specific things, because everything is written out. Everything's spelled out. So there's no question as to whose responsibility it is. Okay. Concurrent. Okay. So now we're going to kind of move on to concurrent ownership. Okay, now this is going to be a listening and writing stuff, okay? A concurrent ownership, now we're switching back to ownership of real property. Now there's 3, maybe 4 ways, but we'll work on just the 3. That way we keep it simple because, you know, COVID, I have to make everything as simple as possible. Okay, if you want to buy a piece of property and you're buying it with somebody else, I'm gonna give you a couple of examples on the type of ownership that you could possibly have. So tenancy in common, I'll write that down for you in your little chat here. There we go. Extra nice, I think. I don't know why. Tenancy in common is when 2 people own a undivided interest in the property. So I'm going to use, now I tested this out earlier. Here we go, everyone. I'm going to play with this whiteboard thingy. Okay, I'm going to try to demonstrate. Oh, there's stuff on it already. How do I clear this stupid thing? Clear all drawings. Okay, so let's say this circle is your home. And if it's tenancy in common, each side owns half. But it's not like one side owns the left hand and one side owns the right hand. Each of the tenants in common own a 1/2 interest, okay? It's not top and bottom, it's not whatever, it's an undivided 1/2 interest. I'm very proud of myself that I'm able to use this, so I'm you know, embellishing on it a little bit more. So that is tenancy in common. So again, now I'm going to explain a couple of other things. When you own a piece of property as tenants in common, what you can do with it. So let's say it's me, and the most typical things are, let's say, you know, mother, let's say brother, sister, or it can be brother, brother, it could be, you know, girlfriend, boyfriend. So they're not married yet, okay? And they own this as 50% owners. So each side can actually sell their half. Now, think about it realistically. If you own half a piece of property, how are you going to sell it? Like, what's this other person going to do? Are they going to like live with the original owner? Like, how does that work, right? So it's not always a good idea to own things in concurrent ownership with somebody else, the tenancy in common, because you have to think about the future. What's going to happen to your half? If you both decide to sell it and then divide the money, fine. Or if one person buys out the other person, then that's fine as well. So that is the tenancy in common. The next one, I'm gonna clear this thing. Okay, the next one, I'm just looking at my notes here. Blah, 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 blah. Joint tenants with rights of survivorship. This one is like, if you like to gamble, this is really the one for you. So tenants with rights of survivorship is, again, 2 people owning it. I'm gonna try this thingy here. Tenants rights of survivorship. That's how you spell it, survivorship. So tenants with rights of survivorship is like a gamble. Basically, whoever outlives, I don't know, whoever outlives the other gets the entire pie. All you have to do is survive, outlive the other person. Now, when do you think, what is the most common scenario associated with joint tenants with rights of survivorship?
Car ownership or checking accounts?
No, think real property. I'm talking about just real property.
Oh, just a house.
Yeah.
Like
What relationship between 2 people would most likely lend itself to joint tenants with rights of survivorship?
marriage.
Wife and a
Husband and
husband?
wife.
Not husband and
Marriage?
wife.
Marriage?
There's a different, no, marriage, different designation actually.
Like brothers
But
or sisters?
no.
Parents and children.
Yeah.
That one?
Parents and children. Yep, somebody said it here. Parents with children. Yeah, the most common actually designation with joint tenants with rights of survivorship is when it's a parent and a child relationship. Why? Because mom and daughter or mom and son say, all right, hey, we're going to buy this house together. Son, daughter, you know, thank you so much. You've always taken care of me. The house is going to be both our names with rights of survivorship. So when I die, you get the entire thing. So that's the most common scenario. The final one is joint tenants with rights. It's called tenancy by the entirety. Okay. You know, I'm going to give you this one. Here we go. Copy. Can you see my notes when I do this or no?
Not at the moment, we can't.
No, it's
Okay.
blank right now.
All right. Let me go back into, I'm not going to draw anymore. How do I get back into my screen? Oh, the difficulties of life. Okay, so chat. So this is joint tenants with rights of survivorship. Most important thing is the death of one, the other gets. And then the last one is tenancy by the entirety. And tenancy by the entirety is the marriage. That's the marriage one. So when you own something as tenancy by the entirety, it's actually the one designation that gives you the most protection against creditors. And the only way to own a piece of property as tenants by the entirety is to be married at the time of ownership. So if any of you own real property, I want you to take a look at your deeds and see how it's written. Is it tenancy in common? The default is, by the way, tenancy in common unless tenants with rights of survivorship is written or tenancy by the entirety. Sometimes they won't do tenancy by the entirety, but they will say, you know, Jane Smith and John Smith as husband and wife. It gives the attachment of the tenancy by the entirety. So again, I'm going to just reiterate that gives you, this is a write it down moment. This is what gives you a right of protection against creditors. So a creditor cannot attach a lien if it's against one person or the other because the house is owned by those two. So it's as if like it gives the husband and wife couple, it's, you know, like the most protection. So that's that. Any questions on those things before I move along?
So the creditor can place a lien on the husband if the wife was the issue, or it can place a lien on
the real
either
property
one? Okay,
on the actual real property. They can, let's say the husband had a checking account and they were suing the husband, they can like perhaps put a lien on their checking account, but they wouldn't be able to put a lien on the residential home, the family home, because one of them owned. Okay.
Yeah.
Okay. Any other questions? I'm gonna move along. It's already 7:15. My goodness, this class flies by. Okay, we already talked about condos, co-ops, right? So that's all that fun stuff is good, done. I'm not gonna go into easements. I hated easements in all honesty. I'm gonna just tell you really quick about easements, but this is not something, you know, you can even ignore me if you want to. So an easement is basically an access to a piece of property that's owned by you. So you could own a piece of property, right? But let's say the backyard, there's an easement. So strangers can kind of walk on there because it's needed. They need to go through that particular space so they can get to the beach or they can get to the other road. And there's no other way except to go through your backyard. Like there's an easement there. So it's access to members of the public to access to be on your property that you own, and then for them to kind of access something else. So sometimes in dead end streets, you might have easements that lead to like a back end street, sometimes with beaches or things like that. They are somewhat common. So if you're going to buy a piece of property and there's an easement on it, definitely think twice about it because it does take away from the value of the land and the ownership aspect of it. Okay. I hate them, but you know, that's just I don't want to, you know, prejudice you or anything. Okay, so that takes care of chapter 48. I'm going to move on to chapter 49. Look at my syllabus also. I forgot to pull it up for today. Today's Wednesday. Syllabus. I just want to see how far I have to get to because I need to make sure I cover the stuff on the exam. Today is, I only have to do 49 and 50. We might actually end early today, guys. That's great. Okay, so you know what? Let me do the secret message now. Secret message time for attendance purposes. Secret message time for attendance purposes. So the secret message is, I like to drink Yoo-hoo chocolate with sponge cake. I like to drink Yoo-hoo chocolate with sponge cake. One more time. I have to write this down, of course, because these are so ludicrous that I'm not going to remember them. I like to drink Yoo-hoo chocolate with sponge cake. Again, that's going to be for attendance purposes for September 9th. To recap, as long as you have 10 secret phrases, you will get 100% on your attendance portion of this class, which is 10% of your grade. So it's 10%, pretty good. So make sure you have that. Okay, so now I'm going to start with chapter 49. And chapter 49 is, again, about real property and the transfer of real property. Most often, the transfer of real property happens when you buy and sell. That's the most common thing that we have here. But you can also transfer real property by conveying it in a will. Okay, so when I talk about buying and selling real property, at the very basic, this is a listening. Back in the day, I will tell you this was definitely something I would test on, but since it's not something that you would write in, we're gonna do away with that for the first exam. So this is, you really are, this is you're getting away with a lot. My exams used to be so much harder, but that's okay. Okay, so at the very basic, when you have a contract between two people and you're selling real property, it has to have these 5 elements. And the 5 elements, I'm going to put it down in your chat. That way you also have that. Okay, and I'm going to just go over them, but I just wrote them out for you. So the names and addresses of the parties, a description of the property, time for conveyance, which is the closing, the type of deed, which is the whole tenancy in common, joint tenants with us of survivorship, or tenancy by the entirety, and the price and manner of payment. Well, how much am I buying or selling this piece of property? And how am I paying? Is it cash? Is it mortgage? What is it? So those are the 5 basic elements, and they have to be in a contract in order for it to be a valid contract for the sale of real property. And when you sell a piece of property, typically speaking, you want that piece of property to be free and clear of any liens or leases. You want it to have a proper chain of title. And what that means is you want to buy a piece of property that went through the vetting process and that's owned correctly by the person that's selling it to you. Because what you don't want to happen is you don't want to be sold a piece of property that's actually owned by someone else. And you may laugh and say that'll never happen. No, it happens. I have a case right now actually where that's exactly what's going on. And I'll give you briefly, you have a grandmother who left her real property, her home, to her grandkids. She hated her kids. Her kids went to a seller, a neighbor, and they said, hey, we're the kids, we own this piece of property, and they sold it to a neighbor. They got the money. Then their kids found out that they sold the property, and this case has now been in litigation for, I have lost track of how many years, because the title company got involved, courts got involved, there's a probate of the will, whether or not it's a valid will. So those things can happen. So when you're buying a piece of property, you want to have a title company, you want to have insurance on it to make sure that you're actually buying something that is legitimately owned by that person. That way you don't get screwed later. And that's what title searches actually reveal. So they're a little pricey, but it's certainly well worth it. You want to make sure that you kind of get that done. And when you buy a piece of property, you are buying it sometimes as is, and sometimes there's a warranty that's on it. If you're buying a piece of new real property that was just built, that new house comes with certain warranties for certain periods of time. So you want to make sure that you kind of are on top of those things. But if you're buying a house that's at a foreclosure or an auction, typically it says it's being sold as is. So you buy it, you get it, whatever it is, you get what you get, and you don't get upset. So if it's great, it's wonderful. And if it's not great, then you're out of luck. But that's why you should have an inspection done. And it's usually at the buyer's expense. But again, it's something that I strongly recommend that you have, even if you're gonna not end up buying the house anyway, because this is somebody that you're paying, and their job is to let you know what all the problems in the house are. That way you know, and you're an informed buyer as to whether or not this is something in your best interest. There's different types of deeds. This is a listening, not a writing. There's warranty, specialty, quick claim deeds. And they basically kind of tell you the type of property it is, and it's a representation of the type of property that you're buying. So a warranty deed says, hey, I'm giving you a warranty that this is actually, my house that I'm selling, and if anything happens, you know what, I'll reimburse you for it. A specialty warranty deed is I haven't done anything to mess up the title, but if it's something that's not me, then I can't guarantee it. It's somebody, up the chain of command, a previous owner perhaps. And a quick claim deed is just whatever rights I think I own, I'm going to pass it on to you. But if I don't own it, that's too bad for you. Again, this is more of like listening stuff, What else do I want to know? You all know what a mortgage is. I'm going to assume that you all know what a mortgage is. So when you actually buy a home, you don't actually own the home, right? Typically speaking, nobody can buy a house on their own cash. Some people can, okay, but maybe most others can't. And so what happens is you have to have a bank lend you this money, and then you promise to pay the bank back over a number of years with blah, blah, blah stuff, right? So the bank is actually the owner of the real property until you have finished paying off all the money you owe them. And then at that point, then you become the owner of the real property. But until then, it's the bank. And so what happens when somebody can no longer afford to pay the mortgage? Foreclosure. That's what happens. So that's kind of you see that a lot. There was a whole bubble. They're saying maybe there's going to be another housing bubble. Who knows what's happening in life. But a foreclosure is when the owner can no longer pay the property. This is a fun thing. Again, I don't test on this generally, but I think it's awesome. It's a concept in the legal system called adverse possession. I'm going to put it in your chat only because I think it's awesome, and I would love for one of my students to eventually do this. And it's the theory of adverse possession. So you know how, actually, I don't want you to do it because I don't want you to do it and get hurt and then blame me. So again, full disclosure, do not do this, do not do this, do not do this. I'm not implying, recommending, or suggesting you do this in any which way or other. But adverse possession is this whole theory where, like, you know how there's all these abandoned houses, like let's say on Staten Island or wherever. So if you go into one of these abandoned houses and you decide to make it your own, you tear down the wooden planks and you like put curtains up and you fix it all up, and you start, like you call Con Ed and you call, the gas company National Grid, and you start having like utilities go into that house and you start living there and you take care of the property. If you actually own it and do this for a number of years, I believe it's 20 years.
20 years is what I read.
Huh?
I read 20 years.
20, yeah,
20 years is what I have as well. So if you do it for, I'm glad people are reading. If you do this for 20 years, you have just become a prime owner of this piece of property.
Isn't that like squatting though?
So it's not so much squatting, it's adverse possession. So squatting is if you were, like somebody was lending it to you and you were renting it and then you decide to never leave. This is an abandoned piece of property that you're kind of like taking over. Nobody's bothering you. Nobody's telling you to get out. So as long as nobody tells you to get out,
I think the key tenets were that it has to be open, that like it's
open and notorious that you have possessed this. So that's why I'm saying you're going to put up your curtains, you're going to invite people over, you are going to make this your own. And if nobody bothers you for a period of 20 years, you just claim this piece of property. But if they do bother you, then you kind of have to get out because it's not yours. So it's a risk, a gamble you take.
So let's say you're living there for a couple of years and they know that you're in there. They can just kick you out, correct?
Yeah, because it's not yours.
Yeah, so you don't have to
be
pay
able
any
to
mortgage
maintain
or
it.
anything,
You don't have
right?
to pay anything. No.
Oh, that's
no.
awesome. I should
That's
do
what
that.
I'm saying.
You just got to
That's
be
what I'm
super
saying.
low key.
No, you have to openly and notoriously own it. Like you cannot be low key where you're hiding behind the wooden planks, you know, like it's got to be, you have to make you have to put your stake into this, you know, like you
so
own it.
the risk is you end up putting all your money and everything, and then at the end of the day, whatever is in there, you lose it.
Correct.
Right?
Correct.
Oh, that's crazy.
So it's a gamble. It's a gamble. I'm not saying it's definitive, but you know, it's something to consider. I like to give you these fun facts, fun crazy facts.
What about
is
after
this for
20
all
years?
states?
Are they?
Oh, sorry.
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 I was saying, what about after 20 years? Are they allowed to kick you out?
No. 20 years is the legal amount of time that you can show that you've openly and notoriously lived, inhabited this place. So after 20 years, it's yours. You are now going to claim that based on the legal theory of adverse possession, it is yours.
Wait, so who's the person that's allowed to kick you out? Like the prior
the
owner
actual
or
owners,
okay,
whoever
so like,
owns it. So probably, look, if it's a vacant piece of property, it might have been owned by, you have to look at the title company, right? You have to look at the chain of ownership and see, is it a bank?
Yeah.
Is it people that died and they have no heirs or distributees? We actually had a case where it was a semi-attached home, right? So you have like, it's like, you know, one house on this side, one house on this side, but they're attached down the middle. And one side, let's say the left side, was owned by this really old woman. The next side was a family. The old woman died. She didn't have any family. So what happened was the neighbor, the family, they took over that house and they're like, it's mine. So they decided to start renting it and collecting rent from that property. Nobody came, nobody said anything, and a couple of years passed. And then once the court was notified that this, you know, I don't know how we were notified, but we were notified somehow. So when somebody passes away and they don't have any relatives, the public administrator of the county gets appointed to safeguard their assets and collect their assets. So the public administrator starts looking into this, and then the neighbors, they made a claim as to the legal theory of adverse possession, except that they had only done this for like a couple of years. So the legal theory was not valid because it had not been prescribed. They just scammed and they tried it. They got money, but now like they got caught and they had to pay the rental value for that property that they were renting. Yeah, because it wasn't theirs. They just decided to take over. They're like, oh, well, the old lady told us we could take it. Was there a will? Was there anything in writing to effectuate this? No. So it's your word against the dead person. And that does not hold, water. So it's an interesting theory. Again, if you want to try it, let me know what happens in 20 years. I'll probably still have my Gmail. Send me an email and let me know if it worked.
I have a question on the same page, Professor.
Yeah.
So if they moved to the latest property and started living there, rented their own property, there is nothing wrong with that, right?
If they took over the old lady's property and they rented their own property?
Correct. They started living in the old lady's property
well,
and renting
they
their
wouldn't
own.
have they wouldn't have had to pay back the rent, but the public administrator could have potentially said, you are renting, you are living in this place, you have to pay rent. You can't live there for free, because somebody's now like, being adversarial to that interest. It's not like a hunky like, it's not like, oh, everything is great and wonderful. No, now somebody's challenging you being in that physical space. And so again, now they had to get an attorney, they had to fight it. They eventually got out pretty quick because they knew it wasn't theirs, but they got away with it for a few years, I don't even think that they had to pay the entire amount of like all the money that they got. So they probably got away with some of it, but they claimed the theory of adverse possession. So,
Professor, I have a question.
Sure.
Is anything apply to the renting? If you stay more than 10 or 20 years, you can like go for get the property?
If it's 20 years, adverse possession right now, I believe in New York it's 20 years. It may be different in different states. Maybe it's 20 years in other states as well, but I believe in New York it's also 20. So if you're thinking seriously about doing this, you might want to look at the state that you want to do it in, the county, you know, and try it for fun. All right.
What if, sorry, I just have a quick question. What if
Sure.
this house, like, you know, in those middle west states where their neighbors are like 5 miles apart
Yeah.
and stuff like that? What if you do that and then no one like really cares?
So you just got a free house.
So nothing will happen to you.
Again, I cannot guarantee, let me just be clear here. I cannot guarantee that nothing will happen. Maybe somebody will go in there and kill you. I don't know. Maybe somebody will go in there and say, that's not your house. We are the long lost relatives. But you don't want to do it in a small town either, because in small towns like that, where the houses are like 5 miles away, they know everybody. So they
Oh no,
see a
I wouldn't do that.
stranger, you know, they're like, who are you? What are you doing here? You know, what's your story? And then you're going to be like, oh, I bought it. Let me tell you. So I have calls that come in. I've gotten 2 or 3 calls within the past few weeks from the public administrator's office. I'm friends with the people over there, and it's legit. Like, they're doing inquiries where they say there's a house on Staten Island where there's people living in there. Is there an estate? Or there's a house on Staten Island where somebody's trying to buy it. Is it in probate? Is there a problem? So, you know, real estate is a hot commodity. It's valuable as well. So can you get away with it? I'm sure that you can. Otherwise, why would this legal theory have been created? But is it something worth the gamble? Like, are you going to go and make this place your own? Because if you're taking over a place like that, it's probably in pretty awful condition, right? So you're going to have to spend some money to, like, you know, make it livable, make it habitable. But is it worth the risk? So that's on you. I'm not, you know, I'm not recommending any one way or the other. So
I believe too. I've seen there are states in the Midwest that are willing to give you property if you go there and improve it. And you don't have to wait 20 years or take that gamble. They're just willing to take it if you go.
They just want people. They want more humans than cows.
Yeah, that is it. So,
there's this thing I saw, and I have to tell you, I started actually looking into it. It wasn't, it was one of those Caribbean islands, and it was one that I really like. Bermuda. It wasn't Bermuda. It wasn't Bermuda. It was a different island, and I can't recall what it was, but they were giving visas now. So you can go there and live and work remotely. And I was like, why am I here if I can go there?
Oh, then maybe it's the Bahamas. I'm pretty sure
Bahamas
it's a B one.
or something.
I read the same thing.
Barbados. I think it's Barbados.
Barbados. There
it's
we
Barbados.
Go. Yep.
I was like, my husband came home, so he told me. So yeah. So I think it would be great, and you know, but again, anyway, I'm going off topic. I want to make sure I get to the stuff that's on the exam, guys. So adverse possession, that was fun. That's not even on your exam. It's just fun fact. I want you to learn something about life. Okay, so that actually concludes the stuff I want you to know for this chapter. I'm going to move on to, I believe, yeah, this is going to be the final chapter. And this is going to be the chapter where I talk to you about and explain things to you where you need to understand certain concepts so you can figure things out for the exam, because a little bit of math involved. So this chapter focuses on fiduciary relationships between people, and when we talk about trusts, trustees, beneficiaries, the different types of trusts and things like that. So I'm not going to test you on trusts, because again, this is a 100 level class, and I don't expect you to know this stuff, but I will tell you just generally. So just listen up, because this is stuff I want to cover, but I will not test you on it. So a trust is basically a legal document that is meant to hold assets. And when I say it's meant to hold assets, is that it's a document or an entity that's created that holds title to assets. So in a trust, it's like setting up like a mini corporation, if you want to think of it that way. And this entity that you're creating can hold your bank accounts, can hold real property. And depending on the type of trust it is, it can be protected again from creditors when you need it to. A fiduciary, when I talk about a fiduciary is somebody who is trusted. It is the person who's going to be managing the trust. It's going to be the person who's managing or the executor. Fiduciary, think of it as the umbrella. It's the person in charge of an estate, a guardianship, a trust, and then depending on what they're in charge of, then it could be an executor, it could be an administrator, it could be a trustee. Those three words I just said, trustee, administrator, executor, those are all fiduciaries, but they are specific types of fiduciaries depending on the actual legal entity. So if we have a will that's being probated, meaning that the family is trying to now like probate this will, get it approved by the judge, the person who's going to be in charge of the estate is named an executor or an executrix, depending male, female. And they are a fiduciary. They're the person in charge. They're the person that's entrusted by the decedent or the testator, the person who created this document, to carry out the decedent, the dead person's wishes. In an administration, meaning there is no will, the fiduciary, again, the person who is charged with carrying out the wishes of the administrator, that's an administrator, administratrix, also a fiduciary. In a guardianship, same thing, it's a guardian. That's probably the easiest one. But a fiduciary is the person who is entrusted to take care of, manage an estate, regardless of it's a trust, a will, an administration, that type of entity. So that's just kind of like lingo. And people create trusts for all sorts of reasons. Most typically, it's so they can protect their assets after death. So it doesn't have to go through the probate court, as some people like to refer to it as. But sometimes it still does, because there's just some problems that happen and the court is going to be the only entity that can solve it. So that's that. When we talk about the duties of a trustee, and again, I'm kind of going over this because it's in your textbook, the duties of a trustee is to carry out the purpose of a trust. It's to be prudent. Remember that reasonable person that we talked about, that perfect person? So a trustee is also supposed to be a perfect person. They're supposed to be managing the money or the assets of the trust carefully and prudently, not to invest it in things like adverse possession, okay? It's a person who is charged of being careful and prudent at all times and making wise decisions to make sure that the purpose of the trust is kind of carried out. And they have to have a high degree of loyalty. A fiduciary in general, whether it's in a trust, a probate, or administration, they are supposed to be loyal and not supposed to screw the people who are supposed to benefit from the trust. Sometimes the trustee, the administrator, the fiduciary may be also getting a piece of the action because they are a child of the person who wrote this will or trust or document, but they can't screw their siblings either. So they have to be, an honest person, essentially, that's going to do right by everybody that's involved, okay? So that's the fiduciary duty and a fiduciary liability. And so that's the stuff with trusts. Wills are much simpler, okay? A will is a much simpler document than a trust. As a matter of fact, a trust is, this is a write it down moment, a trust is often likened to a contract. A trust is often likened to a contract, meaning you need two people to consent to the terms. So a trust is often likened to a contract, meaning it needs two people to agree to the terms. Whereas a will, it's one person. I write whatever I want. It's my stuff and I can give it to whoever I want. Okay. So this stuff is all now like pay attention time, focus, focus, focus. Mental capacity needs to be there when you're doing a will. Now I'm just talking about wills. I'm going to concentrate on wills. The mental capacity of a person writing their will has to be there. Meaning, if I'm writing my own will and I have $1 million in assets, But I think, for instance, that I'm actually poor and I'm homeless and I have no money. There's voices in my head. If I don't actually know the object of my bounty, if I don't actually know what I have, my mental capacity is not quite there, it is not a valid contract. There are certain things that need to be there, and mental capacity is one of them. A will must be written. This is also, write it down. A will must be written by somebody who has to be above the age of 18 or older. So you must be 18 or older to write your own will, to give up your stuff. You have to be 18 or older. So you have to be 18 or older. You have to have mental capacity. Can somebody with a physical disability write their own will? Absolutely. A physical disability doesn't say anything or do anything. If you have Alzheimer's, however, can you have your own will done? You can. It's going to be contested, though, because the mental capacity might not be there. So you need to be when you're now drafting your will, there's an actual ceremony that's done to make sure that it's a valid will. So we make sure that it's a person 18 years or older. You must have, write this down, you must have at least 2 witnesses, okay? You must have at least 2 witnesses. It must be signed at the end thereof. So it must be signed at the end of the will. It's got to be signed. So you sign it. You can't sign your will on page 2 and then go on to 2 other pages giving away stuff. So when you're writing your own will, you have to sign at the end of it. So we talked about the signature. We talked about the witnesses. You must have, again, I cannot stress the mental capacity. It's called like mental capacity, testamentary capacity. I use those interchangeably. The legal term is testamentary capacity. So it means you know and you understand what's going on around you. I'm simplifying this a lot, by the way, okay? So when somebody is putting forward a will, their burden is to show, because they have to show the judge, hey judge, mom died, she left me in the will and I'm supposed to get everything, and she excluded my siblings because she hated them because they sucked. It's not an actual will yet until the judge says it is. So the person who's bringing the will forward, they must prove to the court, it's their burden, that mom at the time of death had proper mental awareness of what was going on, and furthermore, that the will was duly executed, meaning it was signed at the end thereof. The person who signed it was 18 years old. They were not under any type of influence or anything like that. So those are the couple of things that have to be shown. And then it's now up to the other side, the objectant, to say, no, that's not actually what happened. Mom was on a ton of drugs. Mom was so sick, she didn't know it was her own name. And so then you kind of try to poke holes in the other side. And then you can also show additional things like objections are based on undue influence and fraud. And undue influence and fraud are what the person who's objecting to the will have to show in order to knock out a will. So in order to knock out a will, there's 4 things. You have to show that the will was not duly executed, meaning the ceremony did not take place correctly. Like, for example, only 1 person witnessed it instead of 2. That mom did not have the proper testamentary capacity. Mentally, mom wasn't there. Number 3, you know what? Mom was unduly influenced. My sister is rotten. She prevented her from even thinking or doing anything on her own. She was influenced tremendously to keep us out of the will. And last is fraud. Mom didn't even know she was signing a will. Mom thought she was writing us a love letter. So those are the 4 objections that you can have to a will. Does anybody have any questions on that?
I just have a question regarding one of the most cases recently from last year. So we're going backwards to trusts, right?
Okay,
so there was this Jeffrey Epstein case. Basically, he left all the money that he had and the wealth and the properties to a trust, right? Over $500 million. And all of these girls involved in the case, they've been fighting in court for, I don't know, around 10 years already to get some how you call it thing? To get
Some of them,
some
the money from the trust.
yeah, and so there is nothing going on. So what's the outcome of this case? I mean, based on your experience and
Who's trying to get the money out again? Creditors or victims?
The victims were underage girls
Right,
that were
right. So
yeah.
so when you do a
That time
trust,
they were underage. That already
right, when you do a trust, it's to protect against creditors. And so if there's a lawsuit against you for the underage stuff that was done, it's now up to a court to decide whether or not those assets, that trust should be, the document should be, not the document itself broken, but infiltrated in order to get the money out. Depending on the court, depending on the influence, depending on political affiliation, depending on who's in power at what time, if this was a case before me, I would break the trust because the monies obtained were from crimes or things relating to crimes. So if you can tie it into a criminal activity, this would be monies earned or gained from criminal activity. So therefore it should not be protected. That's how I would do it, to try to like break that trust and get funds out of it. Because there's like a clause in the law, especially in criminal law, that says somebody should not profit from their crimes. So the most simplest example to give is if husband kills wife and then he's the beneficiary on her life insurance policy, he should not be getting the life insurance policy proceeds because he killed her, so he should not be profiting from his crimes. Does that make sense? So I'd have to, for the Epstein case, I'd have to tie in the criminal nature in order to be able to break through that trust and get those assets out. Okay?
yeah. Thanks.
Okay, no problem. So now this other thing I'm going to talk about is, again, I need you to focus, and I'm going to be using my, although I think I'm going to try to use the whiteboard again, but this is like mathematical now. And so when we talk about wills and administrations, again, an administration, I'm going to focus on administration first, and then we're going to go into wills. So when somebody passes away and they don't have a will, what happens to their assets? How is it broken down? And I'm going to test on this. So focus. So let's say that, I'm going to do my white screen with our whiteboard here. Okay, so let's say we have husband and wife, and they have 1, 2, and 3. Okay, 1, 2, 3 kids. And let's say they have a combined wealth of $100,000. Okay, in an administration, meaning there's no will, we're going to kill off the husband. Okay, so now husband is survived by wife and kids 1, 2, and 3. How do you think this $100,000 is broken up?
All of it goes to the wife?
Nope. Try again.
Four shares, 25 each.
Nope. Try again.
It goes to the kids.
Nope. Try again.
I remember I'm actually a widow in Pennsylvania where my wife passed. I believe the way it worked out was that I was entitled to, I want to say 50% of her estate, and then her son was entitled to the other half. It was something like that. I don't know if
you're the closest. So I'm gonna, I could have you all guess all night long, but you are the closest. There's actually a formula in New York. So in New York, and that's what I'm gonna test you on. So this is what you need to know. In New York, the spouse, ugh, it's actually harder than I thought. The spouse gets the first 50,000, 50K. plus half the balance. Balance. Okay. So that's the formula. So for basing this, it's always the case, 50,000 plus half of the balance. So if we're basing that on $100,000, how much will the wife take?
50,000.
No, we have $100,000. She's getting the 50,000 plus half, huh?
75.
75,000. 75,000.
Oh, I'm sorry. I missed.
No, no.
Yeah, gotcha.
So she's going to get a total of 75,000. Why? Because she's going to get 50,000 off the top, and then there's a balance of 50,000 left. So she gets half of that. So that's 25,000. So she gets 75,000, and the kids share in that $25,000, and they share that equally. Pay attention. The kids share it equally. It does not matter how old the children are. Okay, it does not matter how old the children are. If one of them is a minor and the others are, 90 years old, it doesn't matter. They share in the assets equally. So now let's say it's husband, and let's say we have 200,000. Okay, 1, 2, and 3. And we have 2 kids, 1 and 2. How much after we kill off 1, how much does the surviving spouse get?
125,000.
No.
150?
150,000. Okay, wait, let me do the math again. Sorry. 50,000. See, I have to do it. 50,000.
175.
50.
50,000. So that's 150. What's 150 divided by 2? 75?
75.
So 75 plus 50 is 125.
Right.
Somebody said that. I don't remember who it was.
Yeah, me.
Okay. So the surviving spouse gets 125, and the balance of the 75,000 is divided between these 2 people, the kids. Okay? I'm going to do another example. Let's say H is a widow, and H has 3 kids, and we're going to go easy, 100K. Now H is dead, 3 kids. How much does each kid get?
$33,000 and some change.
Yeah, they get a third each. So the 100,000 divided by 3 is 33K each. 33 and a third to be exact. Let's say husband, no spouse, not a husband, so a person, human being, human. And there's no spouse and there's no kids. They're survived. Actually, wait, let me clear. Forget this thingy. They're survived by mom and dad, and sibling, brother and sister. BS. How much does mom get? And we have a value of 100K also. So we have human being died. Human died.
25,000.
How much?
25,000.
25, you're saying?
Yes.
No, not 25.
Alphabet?
This is a trick question.
33.3.
Nope. Somebody said it, 50. 50, is that yeah, 50,000. Kini Wow said it. And that is correct. And I will tell you why. You don't move to give the brother and sister anything if mom or dad are alive, because this is considered a secondary class. See, there's a pecking order of who gets your money when you die if there's no will. So the pecking order is, let's clear this out for a minute. The pecking order is your spouse gets assets. Don't even worry about numbers yet. We're going to just go pecking order. Spouse. And if you have children, it's the spouse and the children. If there is no spouse, it's the little kitties that get your money when you die. If there's no spouse and there's no children, then you go up a class. So it's your parents. As long as one of them is alive, they inherit next. The brothers and sisters will never get if at least one of the parents is alive. In order for a brother or sister to get, there has to be no spouse, there has to be no children, and there has to be no parents. I'm not going to bother with you because this goes on and on. There's like, you know, it goes on and on, but that's the level that I want you to know, that pecking order. So if based on that last one I gave you, mom would get 50,000 and dad would get 50,000. Okay, and this is all based on administration. There's one other scenario I'm going to give you that I want you to know, and this is okay, this is now the most complicated. This is as complicated as we get. So if you get this, then you're good to go. So we have husband, wife, and we're going to have 1, 2, and 3 kids, okay? And this person has, let's go with X and Y. This person has, let's see, M, N, and O, and this person doesn't have any kids, okay? So husband, wife have 3 children, 1, 2, and 3, and husband and wife have a total of 5 grandkids. 2 belong to 1, M, N, and O, 3 kids belong to 2. So we're gonna have an estate of, we're gonna keep it simple. We're gonna go with $100,000. Okay? We're gonna kill off H. And now we're going to pretend that wife is left with the total of the 100,000. And now wife is dead, leaving behind $100,000. We're also going to kill off kid number 2. How much does M get? So the most important thing is we're killing off wife, and wife has $100,000. And kid number 2 is also dead, huh?
10,000 for each?
10,000 for each?
Zero.
Nope, not 0.
Like $11,333.
Yeah, it's about 11,000 and change, and I'll tell you why. So the 100,000. Now don't forget, H is already dead, so wife has 100,000. So we're starting off with 100,000, and there's 3 children. Each of these 3 kids are actually entitled to 33 1/3. But number 2 is dead. So that money that number 2 was supposed to get, the 33 1/3, gets funneled down to their 3 children. So M, if I ask you how much is M getting, M is getting 1/3 of the 33 1/3. So divided by 3, it's like 11,000 and change. That's how much M is getting. If, however, we had killed off 1, X would have been in a better shape because X and Y, they only have to share with Y. They only have to share with one other person. So they would have gotten half of the 33,000.
They would have got around 16 or 15 and change, right?
Yeah, like I think like probably 15, maybe 16, 17, something like that. Number 3 is in the best possible shape because they don't have any kids and they're alive. So they're alive, they're going to be inheriting.
That's
so
always.
They get the full 33. Yeah, that's the best one. Stay alive so you can inherit. So that's that. This was actually called the per stirpes method, and this was the method used to calculate interest prior to, I don't know, I think like 1990 something. I don't remember the year, so I might be totally off. Later on, there's a method now called per capita. Okay, I'm gonna tell you, I want you to use per stirpes or per capita. The method now is, hey, we shouldn't penalize 2 for having more than one kid, you know, like 3 kids. And, you know, grandma's money, grandma liked all her kids the same. So if number 1 and number 2 are both dead, well, both of them have to be dead. Number 3 would have gotten the 33rd and a half. That's still the same. The 66 and 2/3, instead of it being split the way, you know how like the 1/3 originally funneled down through 1 and then the other third funneled down through 2, the theory now per capita is grandma's relationship to the grandkids is the same. Grandma loved her 5 children the same. So the 66 and 2/3 would have been divided by 5. And then each kid would have gotten, I don't know, whatever 66 and 2/3 divided by 5. And each one of them would have gotten that. Does that make sense?
Yes.
Excellent.
Somehow
it does. I'm not going to test you as so complicated, but I am going to give you one question that like kind of deals with this scenario. Now, this is all based on administration. Let me close this bad boy. This is all based on administration, meaning, oh, somebody had a question. What if no spouse and no parents, no children, no mom or dad or siblings? I wasn't going to actually even go that far for you guys, but if there are no spouse, no parents, no children, no mom or dad, or no siblings, now it goes to uncles and aunts if they're alive, and then it would fall through to cousins. So if uncle and aunt are also dead, meaning the siblings of my parents, they're also dead. If my parents' siblings had children, meaning my cousins, they would also collect. There'd have to be nobody in order for the state of New York to get your money. Nobody. And it has to be on both sides in order for that to happen. So I'm going to just go back to what I was saying before. So all the scenarios I just gave you are based on administration, meaning there's no will. A will, however, changes that, because in a will, I can say, right, 1, 2, and 3, I can say, we're going to kill off him first. But in his will, he left everything, the 100,000, he left everything to the wife. So the wife would get the entire 100,000. So the will would change how money is actually being divided. No, as a matter of fact, you know what? I die, I leave a will. I hated my wife. I hated her. I only stayed with her for our children, for the sake of the kids. I want to leave everything to my children and exclude her. Guess what? In New York, you cannot exclude a spouse. So you married, you said I do, you entered into that contract, you cannot disinherit your spouse. If, let's say, you say, I'm not going to leave my spouse anything, your surviving spouse can elect something called a right of election. Right of election. And the right of election allows him or her, the surviving spouse, to get 1/3 of the assets. So even though you just try to disinherit your surviving spouse, they get 1/3 of your assets, meaning in this scenario, surviving spouse gets 33 1/3. The balance, 66 2/3, would then be divided between children's 1, 2, and 3. Any questions on that?
So that's the minimum, 1/3. I mean, you can leave
Correct.
1/3, and that's all right with the law.
Yeah, exactly. Even if you leave nothing, their minimum to get is 1/3. If you leave more, then they're going to elect to take the bigger portion. And so they're not going to, they're not going to ask for the right of election because that's less. In a will, you can leave your assets to anybody. As an FYI, there's absolutely nothing that says you're obligated to leave money for your kids. So if your kids are rotten human beings, you don't have to leave them anything. You can totally take them out of a will if you have kids. You can leave assets to charities, pets, there's pet trusts, you know, and you can leave it to anyone you want, any entity, as long as you're, you know, mentally there, go for it. The only person, like I said, you cannot disinherit is a spouse.
I have a question.
The person who's asking, Michaela, you want to ask your question? Go ahead.
Okay, so for the last, well, a few problems with the husband and the wife and the 3 kids, and then the XYMNO. I understand for this, since the number 2 died, the MNO both share the 33%, like they get that divided equally.
Right.
Since the third one had no kid, they get all the money. But for the first one, since they have 2 kids, those kids get any money, or just the person gets the 33?
If number 1 is alive, because we first had them alive and then I killed them off, so if they're alive and they have kids, then they get the 33 and a third. Only if they're dead, then it passes on to their kids.
Thank you.
You're welcome. Anybody else? Because I think that's pretty much all I have for you guys. So if there's I'm gonna post this lecture. I don't know if the whiteboard stuff is gonna come up, you know, honestly, I have no idea. But this is pretty much it. So if you have a question, review the material again, read your book, watch the lectures, and then contact me if you have any questions. So I'm gonna ask again, does anybody have any questions about any of the topics we covered? Going once. Going twice.
I'm sorry, you said
No,
the
go ahead.
test is gonna be in Blackboard, right?
Yes. So that's why I remember I did that sample test, because I wanted to make sure you guys got it, and I shied away from having any like of the questions where you type in and save it. So the exam for next week, it's gonna go live at 6:30 p.m. and you're gonna have from 6:30 to 9:15 to finish it. It's gonna be 33 multiple choice questions. It's gonna be an open book exam. You have a potential of getting, I didn't finalize it yet, but it's basically done. You have a potential of getting up to 109 on it. So there's extra credit questions built into the exam. So the multiple choice questions are all worth 3 points each, except one of them that's worth 4 points each. And there's going to be 2 or 3 true and false, and those are going to be worth like 3 points each. So if it's 3 questions, you have a potential of getting 109. If it's 2, you have a potential of getting 106.
And I'm kind of assuming with that sample test last week, I was unable to take it because I only had my iPad with me. So I assume we won't be able to take the test from an iPad either.
I believe that's the case because somebody else had the same thing. So you want to be in front of a computer to make sure that you're able to take it.
Yep.
Please do not come to me like during exam time and be like, I can't access this. That's why I sent out that sample one. If you would like, and then do it by chat now, or actually raise your hands. There's like a thumbs up thingy. If you want me to do another sample test, multiple choice, and put it out for you guys sometime this week, I'll do that. So I see 1, 2, 3, 4, 5. Okay. Okay, so if you want me to do another sample for you guys to just test it out, that's fine. I'll do another sample. Just a quick one. Make sure that you can access it from a computer. I'll probably play with that tomorrow. It might even be the same questions if I'm able to just do that. That way we can test it out so we can get ready for next week. I don't think it's a hard exam. I think it's the easiest exam I've ever given, the first exam, but that's just my opinion because I know the stuff. So I'm not doing a review because if I give you a review, it's as if I'm basically giving you the answers ahead of time. And since it's an open book exam, I think the 3 hours you'll have are, I think, more than sufficient. Again, just review the material, especially the stuff that I said.
The syllabus is pretty much a review anyway,
yeah,
right?
exactly.
Basically.
The stuff that I reviewed during lecture, focus on that and you will get 100 on the test. There's nothing that I put on that exam that I did not review. I only test on things I went over in class. So the first one wasn't recorded, that's criminal, and whatever we covered that first class, but everything else is stuff that I went over with you. So again, you know, that's why our classes are, you know, hour and a half, 2 hours, or 2+. Okay, any other questions? Going once, going twice. Okay, before we leave off, in case people kind of logged in late, I want to make sure, because I have to do the attendance verification. I know some people put the chat yes, but I sometimes cannot tell who you are when you do that. So I'm going to try, if I didn't call your name in the beginning of class and you know you've been meaningfully participating, then great. I want to review this one more time. Otherwise, you're not going to get counted and you're going to lose any and all financial aid that you may be entitled to. So please just say yes if I call your name. I'm not going to look at the chat now. So Tamik Ebony Bailey, are you here? Tamik Ebony Bailey. Tamik Ebony Bailey. Okay. Next, Daniel Michael Brown. Daniel Michael Brown. Abdullah Hamid. Abdullah, you're here?
Yeah.
Okay, great. Abdul Rahim Husseini. Abdul Rahim Husseini.
All right. Have a good night, Professor.
Okay, good night.
Take care.
You too. Anlin Liu. Anlin Liu. Are you here, Anlin Liu?
I see her responding in chat.
Okay. Nobody wants to follow directions. Okay, thank you. I appreciate that. I'll make that as a yes. Alexandra Marone.
Yeah.
You're here? Okay, great. Timothy Miller.
Yeah, I'm here.
Okay, great. And Renique Scott. Renique?
Yeah, I'm here. I'm here.
Okay, great. Okay, that's all great and dandy. So I'm going to save this and submit it to the registrar. So now that's...
Good night.
Good night, guys. I will see you next week.
Hello.
Hi, Professor.
Like, look at this. This guy was not good at the game at all. He's not going to write my door for the bad. He's actually one on your name. He doesn't even have the owning or good play. Owning is fun. I think I might swap the banning donating. Enough of this. I'm banning Graves. It's right across.